My Lords, I rise to respond to Amendment 97 and to oppose it, the amendment in the name of the noble lady Baroness Finlay. It's actually over 6 months since we last debated this issue at committee in June of last year. Let me begin by welcoming the change in tack. A previous version of the amendment sought to abolish the reasonable chastisement defence outright. Amendment 97 is more measured, given the serious implications that such a change in the law would have for both parents and children. My Lords, in England, the only parents who can use the legal defence of reasonable chastisement are those who use reasonable discipline, like a mum tapping a tot on the back of the hand to teach the child not to play with the electrical sockets at Granny's house. The defence protects parents from being unfairly charged, prosecuted and convicted for smacking their own children, and does so only when no harm was caused and the parent's behaviour is objectively reasonable. We are not talking about allowing parents to get away with abuse, as government ministers have helpfully acknowledged from the dispatch box on previous occasions. Under the reasonable chastisement law, if a parent punishes a child in a way that causes anything more than temporary reddening of the skin, that is unreasonable and therefore illegal. My Lords, some in the media have exploited horrific cases of children being brutalised to try to bolster their case for outlawing mild parental smacking. Let me reiterate, abusers are prosecuted under existing law. The tragic cases we have seen in the press invariably turn out to involve children who were well known to social services, but the social workers were invariably overstretched. Putting thousands more families on the books for nothing more than a tap on the back of the hand or a smack on the bottom will further burden those responsible for child protection, leading to more vulnerable children slipping through the cracks. Amendment 97 requires the Westminster Government to examine the situation in Wales. The Be Reasonable campaign produced a report on the first 3 years of the ban. It found, as we've heard, that over 300 parents have been criminalised and referred to an out-of-court diversion scheme. These are parents whose actions were not abusive. If they were, hopefully they would have been prosecuted, just as they would have been before the law change. Their actions were by definition reasonable, but they have entered the criminal justice system as a result in the change in the law. I do wonder whether public opposition to the ban made Welsh ministers wary of prosecuting hundreds of parents, opting instead for a non-prosecution policy that masked the reality of what they've done. Because during the progress of the bill in Wales, they kept telling people that they were not criminalising smacking. Indeed, the then Deputy Social Services Minister, Julie Morgan, said, "This is not about the government telling parents how to raise their children or about criminalising loving parents." This was silly. If you remove a defence for a specific action, then of course you are criminalising that action. So now in Wales, any report of smacking automatically triggers an investigation by social services or the police. If a parent is referred to the diversion scheme, that information may be recorded against them on the DBS system. So if they work with children or vulnerable adults, they could lose their jobs and livelihoods. The Welsh Government says offences involving a child, quote, will never be eligible for filtering, i.e. from a criminal record check, regardless of the length of time since the offence. So a mum in Wales who taps a toddler on the behind is marked for life as a child abuser. I do not believe that those like the noble Baroness want to see loving parents criminalised and losing their jobs for trying their best to bring up their children. But even well-meaning legislation can have negative consequences. My Lords, the Welsh Government also produced a 3-year review of the law, as it is required to do. Among other things, the report identified an increased workload, quote, for some professionals, particularly in policing and local authorities, unquote. It said this was, quote, due to more time-intensive processes and reclassification of low-level incidents as crimes, unquote. Unsurprisingly, it also said that this led to temporary backlogs. The number of police recordings of, quote, common assault, unquote, on children increased from around 3,900 cases to 6,200 after the law change. It seems highly likely that most of this dramatic increase consists of parents whose actions constituted reasonable chastisement, innocent parents who caused no harm whatsoever. Parents who have fallen foul of a politically correct ban on the kind of loving personal discipline that most of us experienced as children, and many of us, have used as parents. Many noble lords will have received the review published by the Christian Institute called "Does Smacking Contribute to Negative Outcomes for Children?" It analysed 37 peer-reviewed studies. Despite hysterical headlines suggesting that one smack can, quote, scar a child for life, unquote, the review noted that the studies actually showed limited correlation and have never shown that physical punishment causes negative outcomes. Parental depression, poverty, family stability and child temperament are far stronger predictors of outcomes than is smacking. The Welsh Government acknowledged that in the explanatory memorandum to their bill that, quote, there is unlikely to be any research evidence which specifically shows the effects of a light and infrequent smack as being harmful to children, unquote. And they went on, there is no definitive evidence that reasonable physical punishment causes negative outcomes for children. But in their misplaced zeal, they went ahead and criminalised hundreds of innocent parents anyway. My lords, if the government were to properly examine what is happening in Wales, and that would require more information than the Welsh Government has hitherto released, it would show that banning smacking is both unjust and counterproductive. My lords, I therefore invite your lordship's house to reject this sincere but nevertheless wrong-headed amendment.
My lords, I too oppose the removal of the defence of reasonable punishment. I realise that the noble Baroness Findlay's amendment number 97 no longer does that directly, but it is intended as a staging post, and this is why I would like to talk about the issue. As a child, I was subjected to physical punishment. My parents were overly strict. My father came from a military background, and my mother had little patience with children. I was also a boarder at a Catholic school, where the nuns were extremely strict. On one occasion, I was caught talking to my neighbour and was made to kneel on the platform by the teacher's desk with tape placed over my mouth for the rest of the lesson. This was clear violation, and it would rightly be unacceptable today. But, my lords, we must draw a distinction between physical punishment and between hitting a child and an occasional light smack that causes no harm. These are not the same, neither morally, psychologically, or legally. English law reflects that distinction. Any punishment that causes injury, leaves marks, involves implements, or amounts to abuse is illegal and rightly prosecuted. The defense of reasonable punishment applies only to the lightest chastisement where no harm is caused. It does not excuse abuse nor physical punishment. It prevents ordinary parents from being treated as criminals when, from time to time, they apply a proportionate form of discipline to an unruly child. To remove it is another step towards a nanny state, where the balance between parental responsibility and state intervention is quietly but significantly shifted away from families and towards government control. My lords, all children are not the same. Some respond to a word or a look and never need to be scolded. Others test the boundaries. For those children, the calm accession of parental authority is not cruelty, but guidance, helping them learn limits, responsibility, and respect for rules. I'm also a parent. On one occasion, after repeatedly warning my eldest son, I smacked him lightly on his bottom. It did not hurt him, but he was so shocked that I actually followed through that he howled in indignation. His pride was hurt. And after that, when I warned him, he believed me. It was not fear, it was authority, exercised once and never repeated. Sadly, surely, my lords, this is not something that should be criminalized. Polling consistently shows that more parents favor remaining and retaining the current law than banning smacking. We're told that the law is unclear. It is not. The current test is simple. If harm is caused, the behavior is illegal. Removing the defense would replace that clarity with subjective judgments, creating confusion for parents, police, and social services. Experience, as my noble friend has talked about, in Wales and Scotland, bans have led to thousands of additional referrals to social services, diverting attention from children who are genuinely at risk. A similar ban in England would cost at least 145 million at a time when services are already under extreme pressure. What is needed is education, support, and awareness, not criminal law. But legal bans invite denunciations, investigation, and fear, not better parenting.
I actually, when I saw the Amendment 97, was pleased to see the focus was on actually the post-implementation review report in terms of the abolition of defence of reasonable punishment, Wales Act. I'm actually keen that the UK government digs deeper into the impact of what's known as the Welsh smacking ban. I'm keen that the government reviews the evidence, reviews the data, and hopefully draws a conclusion that this is not something that should be brought into UK law, but doing that by looking at the evidence. I've been, obviously, as somebody in Wales, have been involved in this debate for some time, have had lots of discussions, done media discussions, spoken on the issue over the years. But having heard the noble Lady Baroness Finlay talk about the report, I felt as though we'd probably read different reports, but also had different interpretations. So that just shows you that is worth digging into. Because I do have some serious reservations about the success of the law change. And I think that there has been some rather unintended, though predictable, outcomes. And so I just want to raise a few of those. Of course, I understand that the movers of this motion, of this amendment, are motivated by concern for abuse of children. But I think it's very important to note that we're all motivated by a concern about abuse for children. This is something that we can share. But one of my worries is the impact of the law change in terms of the pressures it's placing on social services in Wales, in terms of thousands of new referrals that have been made to Welsh social services that have involved the police, that are actually costing millions of pounds and lots of time. And to be honest, it can mean that real abuse is being squeezed out or relativised by what's happening. The influx of referrals is not a surprise when any report of smacking is automatically triggers an investigation by social services, and the escalation of reports is no doubt because of the Welsh Government's guidance to a wide range of organisations who work or care or volunteer with children, that anyone who witnesses a parent smacking a child should immediately contact social services. My concern is that valuable resources are being taken away from protecting children who are at genuine risk of harm and being diverted into trivial cases where harm hasn't been caused, even if people ideologically don't agree with the chastisement of smacking. It's not that the same as abuse. Because even the most zealous anti-smacking campaigner, I thought before I heard some people in this debate, should concede that a well-intentioned tap on the back of a tot's hand or leg by a parent who loves their child is not an abuser. I mean, I was actually a bit shocked when I heard the noble Lord Hampton saying that, you know, any child who says, I don't get a good grade, I'll be beaten, which is a shocking thing to hear a child say. And it's actually illegal to beat a child. In this country. Of course it is. And the idea that that's the same as smacking in the way that the law is permissible in the law in England, that conflation of brutality with smacking and mild physical chastisement, parental discipline, is the kind of sleight of hand that distorts the evidence and makes this a far too emotional discussion and is so insulting to parents. I mean, that's what I found shocking. If we actually examine the guidance notes issued by various Welsh local authorities, you can see how resources that might be best spent protecting children of serious risk of, for example, beating if you don't pass your exams, I think that would be worth investigating, can become diverted. So one example used in one of the guidance notes was a teacher, this is an example, it says, a teacher reported that a young pupil stated his father smacked him because he was naughty. The advice from the Welsh Government was that the teacher should trigger a Section 47 investigation, which would include 2 uniformed officers visiting and talking to the 4-year-old. And it's that sort of escalation and the dragging of the family into the orbit of social services and police forces that I worry about. And obviously there are implications for the workloads of frontline staff with statutory duty to investigate all referrals regardless of severity. That creates a danger of services unable to prioritise cases where there's a genuine risk of abuse or neglect. And that just gets me to another worry I have, that the fact that parents are caught up in this. When the Welsh law change was argued for, supporters insisted that, as we've heard actually, that the law wouldn't be heavy-handed and that the movers, the supporters of the law change, didn't want to criminalise parents. I mean, I thought it would, but I had many of those debates. But I think whether we like it or not, a new criminal category has been created in Wales in which erstwhile parenting styles that some may have disapproved of but were legal is now being dragged into the framework of existing assault laws. And although, to be fair, the Welsh Government has sought to mitigate large-scale prosecutions, and partly, by the way, because the courts are so busy, so they haven't been able to use the courts, and have deployed out-of-court diversionary schemes, nonetheless, parents are being questioned by police, social services, investigated and accused of a criminal activity, and even settled out of court, a criminal activity that's part of the assault of a child scheme. And I think the shame, the humiliation, the injustice, and what's more, I would have thought this would affect, as we've actually heard from a previous speaker, this will affect the employment prospects, because even out-of-court settlements are being added to enhanced DBS checks. So a mom who has gone on one of these courses, education courses, could find that she can't be a care assistant or a childminder because she'd stopped her child running into the road in front of a car by slapping them and somebody reported it. So I do think we've got to consider reputations trashed, parents' jobs at jeopardy, goodness knows what the impact is on family life and parent-child relationships, especially when I hear noble lords comparing maybe a smacking dad and putting him into the same category as a monster who beats his child black and blue. That must be so demoralising. It's certainly unfair, it's disproportionate, and all in the name of positive parenting. I would like to therefore encourage the government to review and look at what's happened in Wales, but maybe with a different set of research and evidence than we've heard today. Because actually a recent literature review of 37 peer-reviewed studies have noticed the tendency to conflate correlation with causation, have noted unrepresentative samples. There is a problem in Wales, by the way, of incomplete data gathering, often different localities collecting data in different ways. Some, it seems to me, ideological rather than scientific assertions being normalised. So I would suggest that the UK government, yes, look at Wales, but no, don't emulate them. And I think that those of us who are concerned about this overreach by the state into parenting and parents' autonomy, who love their children and so on, and conflating that with abuse, I think is really an unworthy way of conducting a serious discussion. We all want children to be safe. And some people think that a tap on the leg is the same as abuse. It isn't.